Breaking news here on Apple out of the DOJ. Eamon Javers has it. Eamon?
Sarah, this is a civil antitrust lawsuit filed in the United States District Court for the District of New Jersey, and it alleges by the DOJ that Apple illegally maintains a monopoly over smartphones by selectively imposing contractual restrictions on and withholding critical access points from developers. The Department of Justice alleges Apple has broken the law, specifically Section 2 of the Sherman Antitrust Act, in 5 specific ways. One, by blocking innovative super apps. They say Apple has disrupted the growth of apps with broad functionality. The second is by suppressing mobile cloud streaming services. They say Apple blocked the development of cloud streaming apps and services that would allow consumers to enjoy what they call high-quality video games and other cloud-based applications without having to pay for expensive smartphone hardware. The third is by excluding cross-platform messaging apps. The Department of Justice says Apple has made the quality of cross-platform messaging worse, less innovative, and less secure for users so that its customers have to keep buying iPhones. The fourth is by diminishing the functionality of non-Apple smartwatches. Apple, they say, has limited the functionality of these third-party smartwatches so that users who purchase the Apple Watch face substantial out-of-pocket costs if they don't keep buying iPhones. And the fifth category here is limiting third-party digital wallets. They say Apple has prevented third-party apps from offering tap-to-pay functionality, inhibiting the creation of cross-platform third-party digital wallets, which, of course, is important in the whole paying ecosystem here. Now, the court process is expected to take months, if not years here. And guys, there's a political overlay to all of this, because if President Biden is to lose to Donald Trump in the fall, it's a Trump Department of Justice that could be in charge of handling the end game of this case, not a Biden one, depending on that election outcome. So it's not at all clear how that would play out, although some of the Trump people were involved in instigating this investigation into Apple in the first place back during the first Trump administration. So a lot of moving parts here, guys. But the Department of Justice now suing Apple on antitrust grounds. Back over to you.
Right. So they started looking into this in 2019 under the first Trump administration. And really, Eamon, it's part of a number of monopoly cases. Or David laughed at that. Yeah. The original Trump administration.
Are you predicting something already?
Nope, just stating facts. Eamon, the part of the other monopoly cases I was going to bring up against other big tech companies, Amazon, Alphabet, they've all been filed as well.
Yeah, and I think if you talk to the people at the Department of Justice, what folks involved here have told me is that they view this really as about the App Store, right? You've got Google and Android apps, and you've got Apple apps, and those two vectors are really the only way for every other company to get to market here. And there's a lot of concern on antitrust grounds that that's just not enough, that if those two companies control the gateway for apps to get through to consumers for every other company, ours included presumably, then they can exert monopolistic power over those apps. And there's a couple of reasons why Apple might want to do that, right? Because if you're in the business of selling expensive hardware like iPhones, you don't necessarily have an incentive to want apps that don't use the iPhone or use compute power that's bigger than what's available on the iPhone. So you think about cloud-based apps or AI-based apps or what they call super apps that use multiple apps within one and allow somebody else to be the gatekeeper there. All of that is something that Apple has an incentive to keep control over. But I think what we're looking at here, guys, is the very early stages now. We'll see the official announcement coming up shortly. And then the very early stages now of what will be a months and years long legal battle between Apple and the United States government.
Yeah, that was going to be my question. I mean, and you said it, years most likely, right? If history proves any guide here, given Microsoft and everything else.
Yeah, and one excerpt here, David, from the case that gives you a sense of the tone from the Department of Justice. They say, rather than respond to competitive threats by offering lower smartphone prices to consumers or better monetization for developers, Apple would meet competitive threats by imposing a series of shape-shifting rules and restrictions in its App Store guidelines and developer agreements that would allow Apple to extract higher fees, thwart innovation, offer a less secure or degraded user experience, and throttle competitive alternatives. So you get a sense of exactly what the DOJ is going after there.
All right, Eamon, stand by. Let's get over to Steve Kovac. He's got more on what it means for the company itself with the stock down 2.5%. Steve.
Yeah, David, I actually got a statement here from Apple responding to the DOJ's lawsuit. I'll go ahead and read it out loud here for you. Quote, at Apple, we innovate every day to make technology people love, designing products that work seamlessly together, protect people's privacy and security, and create a magical experience for our users. This lawsuit threatens who we are and the principles that set Apple products apart in the fiercely competitive markets. If successful, it would hinder our ability to create the kind of technology people expect from Apple, where hardware, software, and services intersect. It would also set a dangerous precedent, empowering government to take a heavy hand in designing people's technology. We believe this lawsuit is wrong on the facts and the law, and we will vigorously defend it. And just some other interesting things here, David and Sarah, that stuck out to me. By the way, I'm looking at some excerpts from the DOJ lawsuit. I have not had a chance to dive through the full thing. But some interesting stuff on the super apps that Eamon was just mentioning. This lawsuit doesn't appear to go after the App Store directly as a whole. Instead, it's focusing on the super apps that Eamon was describing. We've seen this lawsuit between Epic Games and Apple kind of play out through the courts and basically kind of answered the question about Apple's App Store policies, the fees it charges, and so on and so forth, being the only exclusive way to download software to the iPhone. We've seen what happened with that in Europe, but that doesn't seem, at least right now, based on these excerpts I have, that doesn't seem to be what the DOJ is chasing. They're not proposing here saying, you know, there needs to be another kind of app store or anything like that. I would also point to the messaging thing. I know Eamon talked about this a little bit, but basically making the argument that by keeping iMessage sort of exclusive and degrading maybe the regular text message experience, that is anti-competitive. They use an example of what if you buy your kids an Android phone and you can't really talk to them as seamlessly as you could if you bought them an iPhone and things like that. And also the cloud streaming apps. This is another concession we've seen Apple make in the European Union, allowing services like Microsoft's Xbox cloud streaming service on those devices. So that could be one potential easy concession. Same with the payments. They made the same concession in the EU already, letting third-party apps access that near-field communication chip for those tap-to-pay mobile payments guys. So a little bit of difference between what the EU is attacking Apple for and what we're seeing here in this DOJ case. But, of course, we got to read through the whole thing, guys.
Although last week, I think when we talked to Margaret Vestager of the EU, she didn't rule out that they would be looking into a potential violation for Apple on the Digital Markets Act with some of the concessions they've made that might not go all the way, especially if they still continue to impose fees. I guess, Steve, the biggest question investors are going to have with the stock down 2.5% is what does it mean for the growth of the services business, which has been a strong grower.
And that's why the App Store thing is so important here, because, again, I'm not seeing them really call out the App Store. You know, this is what's been pointed at so much. If you want to download an app to your iPhone, you only have one choice, and that's the Apple App Store. It doesn't seem like they're saying that here, which is the opposite of what we've seen in the EU, where Apple has to allow other app stores onto the phone. I don't see that here. I just see them talking about these super apps and these cloud streaming apps and messaging apps. So if they go in a more full way against the App Store the way the EU has, there's the services business. The App Store is massively lucrative for Apple, very high margin business, of course, largely due to the fees that they collect from the other developers. That's been the main complaint. So I can see, you know, the Spotifys and the Matches and other antagonists of Apple throughout this whole process. I can see them being less than happy with this lawsuit.
Department of Justice drops a massive bombshell on Apple in this landmark antitrust lawsuit. Thanks for watching InvestMinder. If you haven't already, make sure to subscribe and hit the notification bell to stay up to date with our latest investing videos. Disclaimer: we are not a professional financial advisory company. This video is for educational and entertainment purposes only. Any information provided should not be considered as financial advice. Brace yourselves, as the Department of Justice has just unleashed a seismic antitrust lawsuit against tech giant Apple, alleging the company's practices have stifled competition and maintained an illegal monopoly over the smartphone market. In this explosive video, we'll unravel the intricate details of the Department of Justice's allegations and explore the potential ramifications for Apple, the tech industry, and consumers alike. So, let's dive right in. The Department of Justice's civil antitrust lawsuit, filed in the United States District Court for the District of New Jersey, accuses Apple of violating Section 2 of the Sherman Antitrust Act in 5 specific ways. Buckle up as we delve into the crux of the Department of Justice's allegations. First, the Department of Justice alleges that Apple has blocked innovative super apps from flourishing, thereby disrupting the growth of applications with broad functionality. These super apps, which combine features from multiple apps into a single platform, pose a threat to Apple's dominance by offering consumers a more seamless and integrated experience. Second, the lawsuit claims that Apple has suppressed the development of mobile cloud streaming services. By blocking cloud streaming apps, Apple has allegedly prevented consumers from enjoying high-quality video games and other cloud-based applications without having to purchase expensive smartphone hardware. This move, according to the Department of Justice, is a strategic ploy to protect Apple's hardware sales. Third, the Department of Justice contends that Apple has excluded cross-platform messaging apps, thereby degrading the quality of communication between users on different platforms. By making cross-platform messaging less innovative, less secure, and less user-friendly, Apple has allegedly coerced its customers into remaining within the iOS ecosystem, further solidifying its monopolistic grip. Fourth, the lawsuit accuses Apple of diminishing the functionality of non-Apple smartwatches. By limiting the capabilities of third-party smartwatches, the Department of Justice argues that Apple has forced users to incur substantial costs if they wish to switch from iPhones to other smartphone brands, effectively locking them into the Apple ecosystem. Finally, the Department of Justice alleges that Apple has limited third-party digital wallets by preventing apps from offering tap-to-pay functionality. This move, according to the lawsuit, has inhibited the creation of cross-platform, third-party digital wallets, further entrenching Apple's dominance in the digital payments landscape. While the legal battle is expected to span months, if not years, the political implications of this case cannot be overlooked. With the 2024 presidential election on the horizon, the outcome could potentially shift the Department of Justice's approach to the case depending on whether President Biden secures re-election or is succeeded by his Republican challenger, Donald Trump. Interestingly, the investigation into Apple's alleged anti-competitive practices was initially instigated during the first Trump administration in 2019, underscoring the bipartisan concern over the tech giant's market power. However, the legal endgame could play out differently under a new administration, adding an intriguing layer of political intrigue to this high-stakes legal drama. As the legal battle between the Department of Justice and Apple intensifies, it's crucial to understand the broader context and implications of this landmark antitrust case. At its core, the Department of Justice's allegations strike at the very heart of Apple's business model and the company's control over the iOS ecosystem. One of the central concerns raised by the Department of Justice is Apple's alleged efforts to stifle competition in the app market. The lawsuit contends that by selectively imposing contractual restrictions and withholding critical access points from developers, Apple has effectively hindered the growth of innovative apps and services that could potentially challenge its dominance. This accusation aligns with long-standing criticisms leveled against Apple's App Store policies, which have been a contentious topic for years. Developers and competitors have often decried the company's strict guidelines and the substantial fees it charges for app sales and in-app purchases, arguing that these practices create an uneven playing field and stifle innovation. The Department of Justice's allegations regarding Apple's suppression of cloud streaming services and cross-platform messaging apps further illustrate the government's concerns over the company's alleged monopolistic tactics. By limiting the functionality of these services, the lawsuit claims, Apple has effectively coerced consumers into remaining within its walled garden, diminishing their ability to seamlessly access content and communicate across different platforms. The Department of Justice's focus on Apple's treatment of third-party smartwatches and digital wallets underscores the company's alleged efforts to extend its dominance beyond the smartphone market. By purportedly degrading the user experience of non-Apple wearables and hampering the development of cross-platform digital wallets, the lawsuit suggests that Apple has leveraged its market power to maintain a competitive advantage in adjacent markets. As the legal proceedings unfold, it's important to consider the potential implications for consumers and the tech industry as a whole. If the Department of Justice's claims are upheld, Apple could be forced to implement sweeping changes to its business practices, potentially opening the door for greater competition and innovation in the smartphone and app markets. However, Apple has vehemently defended its actions, arguing that the Department of Justice's lawsuit threatens the very principles that set its products apart and could empower the government to exert excessive control over the design of consumer technology. The company has vowed to vigorously defend itself, setting the stage for a protracted legal battle that could reshape the tech landscape. While the Department of Justice's antitrust lawsuit against Apple has garnered significant attention, it's important to note that this is not the first time the tech giant has faced scrutiny over its alleged anti-competitive practices. In fact, the case bears similarities to a high-profile legal battle between Apple and Epic Games, the developer behind the popular game Fortnite. The Epic Games case centered around Apple's App Store policies and the fees it charges developers for in-app purchases. Epic challenged these policies, alleging that they constituted anti-competitive behavior, and sought to introduce its own in-app payment system for Fortnite on iOS devices. However, Apple swiftly removed Fortnite from the App Store, triggering a legal showdown that captivated the tech industry. While the outcome of the Epic Games case was mixed, with both sides claiming partial victories, it shed light on the complex dynamics surrounding app stores and the power wielded by companies like Apple and Google, which control the primary gateways for distributing software on their respective platforms. Interestingly, the Department of Justice's current lawsuit appears to take a slightly different approach from the Epic Games case. Rather than directly targeting the App Store as a whole, the Department of Justice seems to be focusing its efforts on specific practices that allegedly stifle competition and innovation, such as the suppression of super apps and cloud streaming services. This strategic shift could be a calculated move by the Department of Justice to avoid the legal complexities and potential pitfalls encountered in the Epic Games case, where the court ultimately upheld Apple's right to maintain a closed ecosystem and charge commissions on in-app purchases. Moreover, the Department of Justice's allegations regarding Apple's treatment of cross-platform messaging apps and third-party digital wallets highlight the government's concerns over the company's alleged efforts to extend its dominance beyond the smartphone market and into adjacent technologies and services. As the case progresses, it will be fascinating to observe how Apple responds to the Department of Justice's claims, and whether the company will be willing to make concessions or introduce changes to its business practices to address the alleged anti-competitive behavior. It's worth noting that Apple has already made certain concessions in markets like the European Union, where it has been forced to allow alternative app stores and third-party payment systems on its devices. However, the company has maintained that these changes do not go far enough and that it will continue to defend its current practices. Regardless of the outcome, the Department of Justice's antitrust lawsuit against Apple represents a significant inflection point in the ongoing debate over the power and influence wielded by big tech companies. The reverberations of this case will likely be felt across the industry, potentially reshaping the competitive landscape and setting new precedents for how these companies operate and interact with developers and consumers. As the battle between the Department of Justice and Apple rages on, it's crucial to consider the potential implications of this antitrust case for the broader tech industry and the future of innovation. While the outcome remains uncertain, one thing is clear. The ripple effects of this legal showdown will undoubtedly extend far beyond the confines of the smartphone market. At the heart of the Department of Justice's allegations lies a fundamental concern that Apple's alleged monopolistic practices have stifled competition, hindered innovation, and ultimately harmed consumers by limiting their choices and access to alternative products and services. If these claims are upheld, the ramifications could be profound. One potential outcome is that Apple could be forced to open up its tightly controlled ecosystem, allowing for greater interoperability and enabling third-party developers to offer alternative app stores, cloud streaming services, and digital wallets without facing the alleged restrictions and limitations currently in place. Such a move could unleash a wave of innovation, as developers and competitors would have greater freedom to experiment with new technologies and business models without being beholden to Apple's stringent rules and fee structures. Consumers, in turn, could benefit from a wider array of choices, potentially leading to lower prices, improved functionality, and a more diverse range of products and services. However, Apple has consistently defended its approach, arguing that its closed ecosystem and strict controls are necessary to ensure the security, privacy, and overall user experience of its products. The company has warned that the Department of Justice's lawsuit could set a dangerous precedent, empowering the government to exert undue influence over the design and development of consumer technology. If Apple prevails in this legal battle, it could solidify the company's dominance and embolden other tech giants to adopt similar closed ecosystems and restrictive practices, potentially stifling competition and innovation in the long run. Beyond the immediate implications for Apple and the tech industry, the Department of Justice's antitrust lawsuit also raises broader questions about the role of government in regulating and overseeing the activities of powerful corporations. As the influence of tech companies continues to grow, there is an ongoing debate about the need for stronger antitrust enforcement and the appropriate balance between fostering innovation and protecting consumer interests. Regardless of the outcome, this case is likely to shape the future trajectory of antitrust laws and regulatory frameworks, potentially setting new precedents for how authorities approach issues of market dominance, anti-competitive behavior, and the role of big tech in shaping the digital landscape. As the legal battle unfolds, it will be crucial for policymakers, industry leaders, and consumers to engage in thoughtful discourse and carefully consider the long-term implications of this pivotal case. The decisions made today will reverberate through the tech industry for years to come, shaping the very nature of innovation and competition in the digital age. In the high-stakes world of tech giants and antitrust battles, the Department of Justice's lawsuit against Apple stands as a watershed moment, a turning point that could redefine the boundaries of competition and innovation in the digital age. As we've explored, the implications of this case extend far beyond the immediate allegations and legal proceedings. It represents a broader reckoning, a pivotal juncture where the very principles that have shaped the tech industry's growth and dominance are being called into question. Will Apple's tightly controlled ecosystem and alleged anti-competitive practices be deemed a necessary safeguard for consumer protection and user experience? Or will they be seen as a barrier to innovation, stifling the very forces of competition that have propelled the tech industry to new heights? The outcome of this legal battle will resonate across boardrooms and courtrooms alike, setting precedents that could reshape the landscape for decades to come. It will test the boundaries of antitrust laws and regulatory frameworks, challenging policymakers and industry leaders to strike a delicate balance between fostering innovation and protecting consumer interests. As the world watches with bated breath, one thing is certain: the reverberations of this case will be felt far beyond the confines of the smartphone market. It will shape the future of technology, influence the trajectory of innovation, and ultimately impact the choices and experiences of consumers worldwide. In the ever-evolving digital age, where tomorrow's disruptions are born from today's innovations, the Department of Justice's antitrust lawsuit against Apple stands as a pivotal moment, a crossroads where the past, present, and future of the tech industry converge. Thank you for joining us on this exploration of one of the most consequential legal battles in the tech world. As always, we appreciate your support and engagement. Be sure to subscribe to our channel and hit the notification bell to stay updated on the latest developments in this captivating saga and other investment insights. Until next time, keep exploring, keep learning, and keep investing wisely.
Thanks again for watching, and good luck with your dividend empire aspirations. Hope you found today's analysis helpful as you look for profitable new stock opportunities. This was InvestMinder. Remember, knowledge equals profit in the stock market. Thanks so much for watching, and please hit that thumbs up button if you got value from this video. Make sure you click to subscribe as well to get our next videos when we reveal the best new insider stock purchases. Invest wisely, trade carefully, and we'll see you next time. Disclaimer: InvestMinder is an independent stock market commentary channel for entertainment and basic informational purposes only. We are not licensed financial professionals and do not provide personalized investing or financial advice. P.S. If you stayed watching until here, you are awesome. Thank you for enabling me to keep making these videos with all the likes and subscribes. Have a great day, and we love you all.